I'm Melissa Landau Steinman. I'm a partner here at Venable. I'm being joined here today by Mark Schamel, another Venable partner. I'm in the advertising and regulatory group. Mark is a litigator, and so we have two unique perspectives to provide here as we talk about advanced sweepstakes and promotions, some of the sort of more cutting edge issues that we see coming up, also a bit of a deeper dive into some of the issues that were talked about in the basics webinar that we had in January. If you have questions, please put them in. We'll try to get to them either now or after the webinar. Buckle up and we will get going. Bear with me for a minute because my technical skills are still warming up. Here's a brief agenda. I'm not going to spend a lot of time talking about it now, but you will get this deck afterwards, and this is sort of meant as a table of contents. You can see we've got a wide variety of issues. Some context here. The lottery has been around in the United States, actually, a little history lesson, since the time of George Washington, pre-revolution. It was used to finance roads and schools and the like. The picture to your right is a picture of a lottery ticket signed by George Washington. And they were very popular for a long time. Then they sort of went through a dip in popularity. People have always had a little bit of a mixed feeling. I think as a society, we've always had a mixed feeling about gambling, the clash of the puritanical view with the love of gambling. But it's important to understand when we talk about this, that lotteries have been around for a long time, but the way that we structure sweepstakes, prize promotions, all gambling, all the different types of laws here is you have sort of the umbrella of lotteries and gambling, and there's sort of the assumption that everything is not okay unless it's okay. Often lotteries and gambling particularly lotteries may be prohibited in state constitutions. Federal law prohibits gambling. But you have these categories of gambling, prize promotions, giveaways that are expressly permitted. Whether it's the idea of regulated and licensed gambling, the state-run lotto that's typically used to raise funds for things like schools or the like. So, we sort of, the roads in pre-revolutionary and just post-colonial America, promotional sweepstakes that are being used to promote a product or charitable raffles. These are sort of the most typical categories we see. But it's important as you evaluate a concept that you think about that it's not necessarily permitted unless you've got that clearance in one of those categories. It's not just, oh, well, if it's not prohibited, then it's okay. So, when we evaluate, the other type of law that you need to think about always is this general unfair and deceptive trade practices, particularly when we're talking about sweepstakes, contest, prize promotions. So, when we evaluate specifically, a lot of the people here want to hear specifically about prize promotions. Well, those are being very heavily regulated, as I don't have to tell you, but it is something of interest. We're seeing active cases brought all the time. The FTC just recently announced a few months ago a case against one of the biggest sort of traditional sweepstakes companies. Buy this and you'll get an entry to win a prize for $10 million. Alleging in that case, this company operates primarily via mailers, and they announced that the company had violated the FTC Act, the Can't Spam Act, and applying one of the FTC's latest theories, dark patterns, which is sort of an evolution of Section 5 and UDAP, that, you know, they had essentially structured the mailers and the online communications in such a way that they were encouraging people to think that they must make a purchase in order to enter. There have been cases against the various sort of mailer companies like this over time, saying, well, they've made older individuals think that they must purchase to win. One of the most famous cases was an older man who showed up in Florida saying, I won $10 million. So this is sort of the next evolution of the cases against the prize notification, using the prize notification type of theories. You can't tell people that they may have won, that they've already won. In this case, probably the most outstanding was that the court order, the proposed court order required the company to pay $18.5 million, as well as change how it conducted business online. You see the FCC, which has its contest rule, saying how you must disclose and advertise sweepstakes, disclose terms and conditions. They bring cases against TV media companies and TV stations. They found one of the TV stations, a licensee, liable for a forfeiture, which is how they impose penalties of $20,000, because they failed to conduct their contest as they had represented they would to the company, to the public, by excluding an entrant that they determined wasn't eligible. They did not follow their own rules, basically, and the rules were ambiguous. Another case involved $21 million penalties. So these are real cases. They're brought all the time. They're brought at the federal and state level. So when we look at a, sorry about that. When you get a proposal for some sort of, you know, the next great idea in prize promotions, the number one thing to do is first look at, you know, is this an illegal lottery? Is this illegal gambling? The way a lottery is defined under federal, state law, pretty much universally, is a prize is awarded. That's usually pretty obvious, although we'll look at that a little bit. The winners are determined on the basis of chance, and the participant must submit consideration to enter. We're generally familiar with what a purchase or payment, you know, looks like to enter. The tough question generally tends to be, what is non-monetary consideration? Also, one thing that comes up in looking at whether is this gambling, which is sort of, a lottery is one type of gambling, but there are other types as well. Is there some sort of wager or something staked upon the outcome of the game? If you've got something where you actually have to bet money, and you're going to lose that money, that may trigger other regulations. So it's important to look at, you know, is the person staking money on the outcome, on what happens? Is the money actually part of the prize pool? Do things look like gambling games? If so, you may be triggering additional regulations, licensing requirements, whole other agencies, and disclosure requirements. So it's important to think about that. Ooh, did I get that? Another thing to consider about, I mentioned this briefly, but while there are specific laws that may regulate gambling, which we just mentioned, sweepstakes and prize promotions requiring specific disclosures and rules, posting, in some cases registration. This was discussed in the basics when you have to register or bond sweepstakes. The basics presentation, by the way, is posted on Venable's website now if you want to go back and listen to that and learn about those rules requirements or registration and bonding requirements. But even if there's no specific state sweepstakes or contest law in a given state, because there's not always one, you do have to consider whether there's case law, because sometimes cases go back, decades and decades, that are still on the books, as well as attorney general opinions that will still be used to evaluate in some cases by the courts, by attorneys general, whether your promotion is legal. And there's also the unfair and deceptive acts and practices laws. The first case we discussed today, the FTC used UDAP and this dark patterns theory to evaluate whether disclosures that were being made were effective, whether they were being presented in a way that consumers would see them and understand them. Additionally, the FTC has brought many more of these Section 5 actions. To the extent that there are unfair promotional tactics being used, if you're using a free alternative method of entry, but it's not being clearly and conspicuously disclosed, which is probably the number one type of case we see when it comes to sweepstakes and contests, in terms of, investigations, prosecutions, class actions, that may lead to consumer complaints. Which then lead to letters from attorneys general saying essentially explain yourself, or even without those letters may lead to investigations by the FTC, by attorneys general. Occasionally you get legislation on top of that. The use of graphic mechanisms, other interactive mechanisms that may lead consumers to act, whether it's sign up for this auto renewal program and you'll get an entry, refer a friend and you'll get an entry, without adequate compliance with the relevant laws, can also lead to regulatory enforcement. So it's important to make sure that you are complying with all of the laws that may be implicated in your promotion. It's not just about the sweepstakes laws. Although those are super important, it's about complying with all of the consumer protection laws that may be triggered by a given promotional idea. Also, the more that a participating consumer stands to lose, then obviously the higher the stakes are, the more interested a regulator or a class action lawyer is likely to be interested. When we talk about what is consideration, this is one of the things I get the most questions about. Well, it's tough. Many states, probably the majority of states, think about consideration only in terms of monetary or non-monetary consideration. So that's the good news. Now, monetary consideration is, of course, a payment, but most frequently in a promotional sweepstakes, it's about, is a purchase required? Sometimes that purchase is obvious. You must buy this in order to enter. Sometimes it's less obvious. For instance, if you have a photo contest and you want the photo, or sweepstakes, as we're more frequently seeing, take a photo and submit it, and that will be your entry. If you want that photo to feature your branding, then that is an implicit purchase requirement. So you need to think about either running it as a contest, which may still trigger a few states' laws, even where you've removed the chance. Some states, even with their skill contest laws, forbid a purchase. But you also need to think about, if you want to avoid the problem with sweepstakes laws of an implied purchase requirement, perhaps saying, hey, or, draw your own branding, or submit a 20-word explanation of why you love our brand. No purchase requirement there. So think about whether you've implied a purchase requirement. When we talk about non-monetary consideration, there is a group of states that say that non-monetary consideration is illegal, expressly specifying that in their laws. Some states just don't address it, so they may be risky as well. Many states, there's case law then defining what they mean by illegal non-monetary consideration, and it's kind of a spectrum. There's a very low degree that may, in many states, apply. The sort of definitions of impermissible non-monetary consideration can range from the sort of law school definition of an economic benefit to the sponsor, which is obviously the strictest, to, the even a peppercorn, to, well, it has to be some substantial commitment of time or effort, a single store visit in order to enter or in order to pick up the prize, which we'll talk about in a second, may be sufficient in Ohio, say, or it may require more than one visit in a couple of states. There's case law saying that. So, there's sort of been a general, I'm not going to say consensus, but way of thinking about what's high risk and what's low risk. A short survey, probably okay. A lengthy survey that takes more than a couple of minutes, a couple of questions, probably too much. A long scavenger hunt, too much. Opening an account that you've got to put money into, with the exception of a very specific exception for certain banking required, where banking sweepstakes that are heavily regulated, probably too much. Required donations to third parties, probably too much. And we'll talk about charitable sweepstakes a little later. But low risk things requiring registration to a loyalty program, downloading a free app, listening to a radio or TV program, there's actually a Supreme Court case saying that's okay. So some examples here, regardless, you want to make sure that the requirement is clearly and conspicuously disclosed. A travel requirement, for instance, is kind of in a gray zone, but if you're going to impose it, you definitely want to make sure that that is in the abbreviated rules, not just in the rules, that it's required so people can decide, do they want to enter? Another thing that we get questions about is post-consideration okay? The idea that you may need to travel, make a purchase, spend some additional money in order to get the prize. Certainly it needs to be disclosed up front. There is some risk. Some states have these prize or gift notification statutes that talk about them. For instance, Connecticut has a law that prohibits advertising as sweepstakes if there's any condition or restriction attached, unless it's unless the condition or restriction to claim the prize is through a method that does not require a purchase, payment of a fee, or any other consideration. There are these old bank night cases, as we call them, that prohibited sweepstakes that required attendance at a sales pitch. Some other states said it's okay. So this is one of those things that there is some risk, and again, you want to disclose. The free alternative method of entry. It's clear it needs to be disclosed up front. There's a couple of other key sort of conditions here. It needs to be offered what's called equal dignity to the, quote, paid method of entry. People who are entering for free need to have the same number of opportunities to enter. You can't have unlimited entries for the free entrance and then just one for the paid. It can't be unduly onerous to enter. A stamp is okay. But you can't make it much harder. You have to allow for sufficient time for the free entries to be received, which is something that becomes increasingly important to pay attention to nowadays with digital sweepstakes, where everything moves so quickly. If you've got a mail-in entry, you're either going to have to delay selecting the winner, or you have to consider whether you don't want an email method of entry or asking people to fill out an online form or something like that. You also can't sort of impose substantial additional requirements like you must fill out an essay or something like that, because that's not going to be equal dignity. Note that, and we'll talk a little bit about international requirements later, but there are some countries that allow you to require a purchase without requiring a free method of entry. So Australia is one requirement. But here, the argument that, oh, well, you're just buying a product that you were going to buy anyway, may work in some states, but it won't work in all 50 states. So the other interesting point is there is a group of cases. There are cases in several contexts where courts have held that the mere fact that you're offering a free alternative method of entry is not necessarily outside of the context of a purely promotional game of chance, a get out of jail free card, as we say. So what does that mean? Because I think many of us think that that's always the case. Promotional sweepstakes are generally defined as a sweepstakes that is offered to promote a specific product or service on an occasional basis, as opposed to all the time. So most of the time, if you are a CPG brand or a brand that sells to consumers, you are going to be offering a traditional prize promotion sweepstakes. It gets tricky, however, if you're offering essentially a sweepstakes with a product attached. Or something like that. So there's this group of cases called the face trading cases, or the ad tabs cases, where there was a a coupon book being offered via a machine in stores. There are similar cases that have been offered involving phone cards or internet times that were offered in convenience stores, all of which, in which all of them, the courts found that essentially the product being offered was not the point. That really the point was offering the participants the opportunity to gamble. The games being offered had generally some sort of gambling interface, although that wasn't the case in the face trading cases. They were being offered all the time. There was no break. They were constant. And there was evidence presented in the cases that people were basically throwing away the product, dropping they would find the coupon books or the cards or whatever on the floor, next to the distribution, the video terminals. Mark will talk a little bit more about these, but and so they found that essentially it was a subterfuge, the product for gambling. So it's important to think about, are you offering an AMOE to justify the game, or are you promoting a product? Regardless, you must always clearly and conspicuously disclose the free AMO. This is the basis for any number of cases where you're sort of putting the free alternative method of entry in teeny tiny print and failing to clearly and conspicuously disclose it. Regulators would take the position that it should be equally as large as the paid method of entry. Generally speaking, that doesn't always happen, but it certainly should be clear and near to the place where you are disclosing how to enter via the paid method of entry or the non-free. So it can't just be buried in the rules. Okay.
While you switch that, Melissa, can I just give everybody
Of course.
the code for those that want CLE credit? The code is giveaways, GIVEAWAYS plural 2024. So there's a link that you saw in there as giveaways 2024. Sorry.
No, that's great, and that'll make me. So another question is, are you giving away a prize with any value? I'm going to start to speed up a little bit because I get involved. And so this comes up sometimes, but less often. We're seeing it come up more in two contexts. The first is like if you're just saying, oh, we'll post your video that you submit or that sort of thing. That generally is viewed as being not of any value. And you can make the argument that this isn't necessarily a lottery if that's the case. The other place where it's coming up is with NFTs. If there's a newly minted NFT, it doesn't necessarily have any value. However, if there's a secondary market that's active, it may be that you've already got a way to assess value. It's important to try to assess the fair market value of any prize or experience, looking at, is there some sort of objective outside standard? Is there a reasonable equivalent? If you've got, say, you're meeting a celebrity, do they regularly give away the opportunity to meet them in other contexts? Are there meet and greets? Have they been valued before? Sometimes you need to be a little creative and look beyond sort of the immediate context, and you'd be surprised there are often ways to value these things. So there can be a very broad definition of what is value. Even additional game plays have been sort of adjudged, if you will, to have value in some states. But again, that in those cases, they look to value in the secondary market. So it's important to take a look around before you immediately say, well, that doesn't have any value. Also consider that the variation in value between prizes, the fact that everybody wins something doesn't necessarily mean there's no chance. If there's a variation in value between prizes, there could be chance in a giveaway. It's something to look closely at. Another thing to look at, if you have certain specialized types of sweepstakes, entry pools, they may raise special issues. It is okay to limit your entry pool to just customers, but say if you've got an employee promotion, you may have to think about things like, are there tax issues? If you've got a general promotion, do you want to exclude employees due to these issues, due to concerns about fraud? Or do you just want to include the people who are immediately involved in executing that promotion to address any of those fraud issues? Are you imposing additional costs if you have extra verification to ensure that you don't have issues? One question we sometimes get with trade promotions, not employee, but customer promotions, is there are laws in some states saying, look, you can't give prizes to employees of your customers. They're called commercial bribery laws. The government can sometimes have restrictions on giving items of value. So how do you address those? Do you talk to your customers as a practical matter, just to give them a heads up? Do you include language in your rules to say, hey, you can't enter if your employer will not permit that? Another thing to consider, of course, is that promotions targeting children have special issues from a privacy perspective. You need to include language that's clear to them. You need to ensure that there's parental notification. And so there are special rules there. We could do a whole webinar on just children, but before you go forth in that, it's very important to consider the rules about promotions targeting children, and making sure that the parents are notified, and giving consent, and likely participating, and participating as with them. An interesting issue is the fact that when you target promotions, you may be able to target customers, but there are rules about targeting, say, women as opposed, versus just female audiences, or specific, the laws prohibiting discrimination can be triggered. And there are cases out there where there have been lawsuits against Ladies' Day promotions, against other types of promotions that target specific audiences. These laws are applied in different ways based on the state. And some states will balance harm versus rights. But it's important before you say, hey, we really want to target an audience, that you consider the fact that these laws exist. The other thing is that depending on how you decide to provide for entry, you need to think about compliance with the ADA. There have been lawsuits against loyalty programs. In particular, there was a lawsuit against the Container Store alleging that an in-store entry mechanism did not comply with the ADA. We've seen those lawsuits against websites for ADA compliance as well. So usually there's a way to provide alternative methods of entry that can address this, but it's not just a website thing, it's a promotion thing too. Modification clauses. It's important to consider that modification is an entry of last resort. I'm gonna address this quickly to get to the more complicated stuff, but we get these questions all together all the time. You include a modification clause, but it's not really meant to be used. This is where the consumer protection overlay really comes in. Where this becomes particularly important, though, right now is with the dispute resolution clauses, and that comes up a lot. Arbitration clauses are becoming particularly common now in sweepstakes, but there have been challenges. And a modification clause in some states, for instance, Texas, if it's overly broad, can actually render sort of a contract like a loyalty program or a sweepstakes illusory. And there was a challenge in that Container Store case to that. But this is specifically an issue where there's an arbitration clause as opposed to generally. Which was the challenge. That's the issue with that Texas law. Of course, the official rules are a consumer contract. With arbitration clauses in a consumer contract, you can have concerns about a contract of adhesion. So you can have challenges on that basis, particularly if you're not disclosing the fact that an arbitration clause is present right up at the top of your rules. So that's sort of a drafting tip. But also, you need to make sure that people are seeing and accepting the rules in order for them to even be binding. And so that's that Root versus Robinson case that we've recently seen, where there was a challenge based on the fact that consumers were not being asked to accept rules before they entered a sweepstakes. There's also been a recent case where there were different dispute resolution cases and clauses rather in sweepstakes versus the terms of use for a website. And so this case has gone all the way to the Supreme Court twice now over the issue of, you know, both what clause is going to be the one that is used, as well as when you get to litigate the issue. So you definitely want to make sure that the clause that you have in your sweepstakes rules is the one that you want to be binding, as well as, you know, you have this properly structured, properly disclosed, properly accepted dispute resolution clause. There are other clauses that you may want to think about. You know, what are you doing about class actions? If the arbitration clause is not ultimately binding, how are you going to deal with judging? What about disputes caused by third parties? And, you know, what about issues that generally raise problems about integrity? How are you going to address those? So, user-generated content promotions. When skill contests and UGC promotions, they have all the same issues with rules and the like as traditional sweepstakes, except that you've pulled out chance. So now in most states, as we mentioned, you can have a purchase, except for the 4 states listed here. There are other issues, though. In particular, you're asking people for content, or you're asking for an exercise of skill in order to select the winner. So you want to be very clear about how you're choosing the winner. If there's judging, who the judges are and why they have the expertise necessary to select the winner. What the winner selection criteria will be, so people know how to pitch their entry, how you'll address things like voter fraud. If you're using voting, leaderboards can be risky, because if you do have to address voting, then all of a sudden people are going to be like, wait a minute, I was winning, you know, yesterday, what happened? There are also issues like the fact that people need to disclose the fact that they received an entry into a contest if they're posting content online under the FTC endorsements guides. You need to comply with third-party platform rules if you're posting on those platforms, and IP. So a note about voting in contests. I mentioned some of this before, but it's particularly important to have those clear guidelines and voting rules. There is some question as to whether a voting contest where the public, which has no particular skill in judging, is selecting the winners, is really, if that's really a skill contest, but it's yet to be challenged, and these have been around for a while. So I'm less concerned about that now. What is more concerning is when you have the voting public picking the winner, you as the sponsor lose a lot of control over who the winner is, and you may not like the outcome. So generally, I recommend that you have 2 rounds, where one round is judging. Even though it's a lot more work, it also gives you a lot more control over, you know, who the ultimate winner, whether you choose a pool for the public to vote on, or the public votes to narrow down the pool, and then you as the sponsor choose the ultimate winner. There is a recent class action that's sort of interesting in this area that involved the favorite chef contest, where people bought additional hero votes. The class action alleged that the practice of buying these votes was actually essentially, you know, a lottery. The case was actually ultimately dismissed. The motion to class for certification was denied. The motion, it was dismissed. Basically, the finding was there was no possible case because there was no economic injury to the plaintiffs. The plaintiffs were not the protected class here. And there was no RICO claim, there was no UDAP claim. So it was a very interesting case. Also because there was a charity that was benefiting here. Feeding America would receive 25% of the donation, as was disclosed. So these voting contests are, they have not gone unchallenged, although we have not seen that many cases. A really important problem with you or consideration with user-generated content contests is the fact that there is inevitably intellectual property in the posting. So it's really important to take account of that in the rules. To the extent that these are posted on your website, that you may want to use these entries for future purposes. The fact that the postings may be posted online, you can't necessarily repost them because you don't have rights in them. So, there's copyright in the images, the photographs, to the extent people are reposting third-party content, reusing music. These can result in copyright violations. You can be liable for contributory infringement. There may be third-party logos, some of them sometimes very sensitive. If you have a Super Bowl contest, people are posting team logos in them. Those are highly sensitive. And very actively enforced by the NFL and the teams. Plus, if third parties are in these, there's a right of publicity, not only for the individual posting, but for every person featured. So you want to have rules in these about the content. You may want to exclude things like music or provide music that can be used if you want music in the videos. But you need to think about that. Do you want a representation regarding, hey, I, the entrant, have gotten the consent from the third parties featured, and I will provide written consent upon request. Although it's hard to rely on those representations to any extent without actually getting that written consent. So there's a balancing act that you really need to do between sort of ease of entry and protecting yourself / getting the rights you want or need. I've seen some in very large and high exposure contests actually provide releases to people who want to enter, for them to sign, for them to get from third parties. And certainly you want to be moderating entries. It's one reason why having people submit content on your website is always a good idea, because it provides for ease of moderation as well as the ability to moderate before you post anything, as opposed to things that are posted, on social before you have a chance to look at it. Of course, you want to reference the requirement or preview what people are going to be asked to do in terms of a winner agreement in the rules as well. And for a very high profile contest, you may want to ask for a background check as well. Oops, sorry. Talking about some of these newer technologies as well. One thing, I think there's this perception now that the metaverse is gone. We don't have to worry about it anymore. The metaverse is here. There are lots and lots of promotions going on. There are lots of new ideas. We see, in particular, the gaming platforms like Fortnite or Roblox are still being used both for games and for promotional games. At South by Southwest, We saw a new metaverse and AI company, Meet Kai, pop up with a virtual reality installation called the Brotherhood Deli, which was selling real world merchandise. And that's another thing, is we have a lot more direct e-commerce on different platforms, including the metaverse. So that's a model that you're going to see a lot of coming up. And then, of course, there's the Apple Vision Pro, which, is going to serve up a lot more in terms of the ability to explore AR, VR, and similar experiences. So you're going to see the types of issues that we were already seeing, whether it's the use of NFTs as prizes or as giveaways. One of the NFTs have been used as prizes, which trigger issues like we talked about valuation. There's also interesting intellectual property issues, how you share them. In addition, to the extent that we have these giveaways on the metaverse, on sort of the distributed internet or W3, there are interesting issues like, how do you provide rules? How do you provide disclosures? Do you have to send people back to a central site? Or, are we providing them through the contracts, the individual sort of contracts that are communicating rights in NFTs on the blockchain? Unfortunately, those really don't give the room to do anything like communicate sweepstakes rules. So the answer is no. Typically, you have to find other ways to communicate something like promotions rules. The terms of platforms like a Fortnite or the like may provide a very limited ability to provide some abbreviated terms, but they don't really provide a huge amount, or the platforms themselves rather than the terms, but they don't provide a huge amount of flexibility. So again, it's necessary to work with the platforms or be creative about how you're going to provide terms and conditions on these newer digital platforms that aren't as centralized, because there's not necessarily the same flexibility as you had on sort of the centralized internet that we're all used to from Google and the like. One of the big issues that's come up with NFTs lately has been the issue of whether NFTs are securities. The SEC has taken the position that yes. The courts, though, have addressed the issue in several cases lately, in Dapper Labs and Ripple Labs, where essentially they've said it's a fact-based determination. Dapper Labs involved an NFT exchange with trading cards. In that case, they found that yes, they were. These trading card exchanges essentially involve sales of individual NFTs that look like digital sports cards or trading cards. Interestingly, there were a number of cases in the 90s that there were challenges to traditional trading cards, saying that, the mechanism where you bought a pack of trading cards and you might get a more or less valuable chase card were violations of the RICO laws and the gambling laws. And there was a split, but generally the outcome was, well, maybe, maybe not. And many courts said no. Ultimately, the tops and the like added a free alternative method of entry where you could get a free card. In the context of these exchanges, the same issue comes up. Like, gee, is there, when you don't know in a group of these cards, whether you'll get the more or less valuable card, or say if there's a group or if they're randomly assigned, is there a lottery issue? That's still sort of unaddressed, but this issue of the collectibles, in Dapper Labs, they said, well, we think it's possible that they could be, as rather securities. In the Ripple Labs case, however, the court said, well, tokenized NFTs are not securities. Institutional NFTs are. So, long story short, this is sort of a TBD, but it's extremely important, if you are offering NFTs, to make sure that they are not securities, and also to include disclosures to that effect in your rules as a protective measure. So this is that discussion. It's important to look at, is there a lottery issue if you're offering NFTs? Are you addressing the IP issues? Are you addressing the disclosure issues? And are you addressing the prize value? Esports, another issue. I'm trying to keep an eye on the time, so I think I'm going to skip through this. Loot boxes are another issue where, in particular, this is not fully sort of shaken out yet in the law, but there is an issue in particular where either children are purchasing them, or loot box items may be sold for cash or for some sort of value. Loot box being items being skins or some other item that may be earned either in a game or where you don't know what you're getting in literally a physical box. The FTC has been looking closely at the issue of loot boxes and sort of items of value that may be awarded in games or other contexts. And there's been a lot of litigation. Generally speaking, defendants have been winning, or the cases have been dismissed, often on Communications Decency Act grounds, saying platforms are not liable. But for now, it's important to clearly disclose odds of what may be received, ideally disclose what the items to be won are, and pay careful attention when children may be involved. So I want to attack AI, and then I'm going to skip forward to the end because we are running out of time on this. AI and promotions. This is like the new hot topic. AI is sort of the big unknown in a lot of ways, but when it comes to promotions, we're seeing it come up more and more. We know the FTC is actively monitoring this topic generally, when it comes to things like fraud and deception, infringements on privacy, other unfair practices. They had a hearing last month. It's important from a general perspective to be thinking about what your AI policy from a compliance perspective and vetting partners will be. And also an important issue to the FTC is going to be disclosures and about when you're using AI. But from a promotions perspective, it's important to think about, we're seeing promotions, like in promotions, issues coming up with the use of AI applications in promotions, concerns about consumers using AI in content that they're submitting in UGC promotions, and sort of how to either prohibit it, screen for it, allow for it, or protect against possibly infringing content showing up. So that's sort of the number one issue is IP. Are you going to use AI in sort of the content that you are, using as part of your promotions? And how do you protect against AI, intellectual property issues? And are you going to permit the use of AI in the content that you are permitting? Because of course, garbage in, garbage out. You may end up with issues from an intellectual property perspective based on what what the AI that has been trained on. So do you want to limit the AI sort of that is permitted in the house? Like, will you only allow a specific contractor, a specific provider to be used? We talked about allowing only specific licensed music to be used. Do you contract with a specific AI provider and allow only that to be used in your promotions, or something like that, where you have a high confidence level or a great indemnification clause? Some considerations. In addition, can you use an AI application to judge your entries? When would that be okay? Is there sufficient context or intent coded into the application to inform that judging? Is it even possible in certain contexts, for judging, a film contest or something like that? Is there empathy enough? Also, if you use AI to train, a character in a skill contest, is that going to be okay from a legal point of view? So interesting issues coming up. A note regarding international considerations. I've really been attacking this from a US perspective in this presentation, but the laws vary considerably in other countries, whether it's prohibition of certain prizes, how they handle AI and the metaverse and loot boxes, registration and bonding requirements for sweepstakes and contests, rules translation. So it's really important, to consider where you're running this and to limit if explicitly who can enter if you're not prepared to comply with the laws of other countries, because you can get in big trouble if you're targeting entrants from other countries but you are not compliant with the laws of those countries. All right, Mark, I'm really sorry for running over, but a few words on the penalties and what's the worst that can happen. Or I can pick it up. We lost Mark. Okay. Words on penalties. Mark Schamel had brought me up to date on our friend Kelly here, who was involved in the sweepstakes machines cases, as we talked about, which was Mark is back. So I'll turn it over to him.
Yeah, Murphy's Law. I know we've run over. My computer literally, I'm on with my phone. I don't know how good the connection is.
By the way, if you have to leave, this will be taped and posted, so you won't miss anything.
I'll fairly quickly. This was the picture of Kelly Mathis, as I heard you saying, as a lawyer for the Allied Veterans case down in Florida. I had one of the lead defendants, and they actually prosecuted the lawyer. And this is a picture that was taken off of the Orlando Sentinel's website, where he is responding to the 6-year sentence he was handed down for being the lawyer that was operating over this entire sweepstakes organization. Thankfully, the conviction was overturned, and the state's attorney's office and the attorney general of Florida decided not to retry him. But the situation here can be dire, and I wanted to make the point that make sure everybody understands these are real cases. And I think some of the things that Melissa said that are important are you need to understand the laws here that go back to really some of the times of Washington, and things haven't, you go back one more. Yep, next one. And things haven't kept up. So we have various federal, state, and municipality doing their investigations and prosecutions, and they're really using a lot of times early 20th century, late 19th century, or older regulations to enforce with modern technology. I mean, we just went through, Melissa talks about NFTs and AI generated, and we have digital, alternative modes of entry, and the laws haven't kept up. And so what you have is you have a combination of local and state and federal law enforcement who don't know this area very well. They're not trained on it. I've had cases where case agent will get on the lead case agent for the state of Ohio, for example, and the entirety of his training on something like this was a class he took at the police academy. It's his induction into the police force 20 years before. So we're dealing with local law enforcement and prosecutors who don't know the law, antiquated laws, and then there's this really the bad luck of what moves them. And I think there's a lot of issues with who decides to go after some of these things and why. And one of the things that we've seen, or at least I've seen in my practice, and I'll be upfront and tell you this, I haven't had any of Melissa's, any of your clients, because you've handled all these things in advance. And so I end up getting the cleanup for other clients who haven't had this in advance. And we come in and they don't have, they aren't prominently displaying the alternative modes of entry, and they're not doing things where they're dealing with the issues that the local jurisdictions may want to deal with. And so you have competing interests in different places from competition and some of the aspects that come up with this. I know that we're listening to here, so I'm going to jump through some of them, but we can talk about who prosecutes these cases. They're quite often prosecuted under the federal laws. They're prosecuted sometimes under state laws by either a state attorney general or a state or a local, the equivalent of a city prosecutor. So you could literally be dealing with somebody. I have one right now in one of the mountain states in the West, and I'm dealing with an AG who on one day might be prosecuting human trafficking and or some sort of drug crime, and the next day is trying to prosecute a complicated sweepstakes case for a major corporation that's working in 30 or 40 different states. So there's real issues here about the inconsistency of enforcement, the motivation for enforcement, and the way the enforcement is carried out. And I think the penalties here, the millions in disgorgement and redress, the civil and criminal penalties, and then there's the individual liability in prison for somebody like Kelly. Thankfully, he did not go to jail, but it happens. And so you have, you think, well, maybe I just have folks that are on the front line that aren't doing this the right way. I've trained them and I've got some coverage. But prosecutors will look at it and they'll say, no, this is a systemic problem. You're not training any of them properly. And so the hourly employees who are making the mistakes, we're going to give them a pass. We're going to turn them into some sort of a witness, and we're going to go after the deep pocket of the company and maybe some of the people in the general counsel's office or in leadership who are running this and causing these problems. Can we flip to the next for me?
We can, if I master this program sometime. Whoop, okay. Is that right?
Yep,
Nope.
that is.
Okay.
And that's just a very short list of some of the possible statutes that are used. It's prosecution and enforcement in this space is really difficult because there's not a lot of statutes that specifically deal with things like sweepstakes, right? So, I think one of my other slides here is walks like a duck, talks like a duck. I actually had a prosecutor say that to me during a meeting when I sat around with 20 other lawyers and we're talking about this case that they're bringing, and they use that analogy because, well, you walk in, we look at it, and it looks like gambling. Well, it's not, and let's talk about it. So we had to hire experts, and we had to bring in somebody to educate them on what the law is. But they're using what's available to try to suppress this industry in a lot of ways, particularly if they think it's competitive with somebody like a local lottery, with a casino. If you have a state that has a casino, has worked out some sort of situation where they have Native American tribe lands, or they have another group that's put in a casino, they will try in some ways to enforce out anybody they can perceive as being in competition. It's interesting because they're not actually not. They've done a lot of studies to show that when you close down these places, and you shut down various sweepstakes that that are interested in doing, there's no sort of influx of people into the organized gambling, legalized gambling. There's no correlation, although the government seems to think there is. One of the other things I think you have to look at and be very much aware of is when you're dealing with these, the way that they prosecute them is to use what's available to them, such as money laundering, conspiracy, wire fraud, and I've listed a few of them. New York State has a number of gaming and money laundering statutes that they use. Felonies, almost all of these are felonies, and the recommended sentences are put next to it. Florida has one. Thankfully, of all the places it's reasonable, it's Florida. And most of theirs are misdemeanors unless they can get you into a larger conspiracy or a money laundering. You want to flip to the next one? I think there's one more.
And this is all in addition to the civil penalties, you know, and UDAP type of penalties. So you've got that fun too.
And I think that's right. And I think one of the things to understand is that with these old laws that are still in effect, and as you said at the very beginning of our presentation, also that we've got a situation where a lot of the cases that they're using for guidance go back decades, right? We have cases that are not even anticipating this type of technology, right? Nobody could have thought in the 70s that everybody was going to be walking around with a potential, as one prosecutor told me, every phone's a gambling device, you know, and so we're all carrying these gambling devices with us, and we're carrying them across state lines, you know, and so for those of you that are operating in places like Connecticut or New York or New Jersey, you've got to be very much aware of where these people are moving on a regular basis within those very different jurisdictions for what the jurisdictional rules are. I mean, if anything, what I would tell you in my experience is you don't want me, you know, Melissa, you don't want to see me or talk to me or hear from me because then something has gone wrong. So I talked about some of these. I think we've cut through most of them. But I think, you know, at this point, Melissa, if you want to answer a couple of questions, I know we've gone way over. I don't think there's another slide, and I apologize. I'm on my phone, so I can't see it unless there is.
Yeah, I mean, I think I've tried to answer some questions. I think we'll probably try to get to more. I do want to, you know, sort of add to your point that that's why, from a compliance perspective, we primarily try to come up with strategies and write rules that comply with, if not all 50 states and territories and possessions, as many as possible. And you know, I think that's probably the most common strategy with sweepstakes and contests, certainly. It then gets a little bit harder with more gambling type strategies because the laws are more focused in a traditional gambling context on registration and licensure. So you have to be ready to commit resources towards, you know, the actual regulatory compliance on a much more active basis. Whereas, you know, registration and bonding is only required in a few states for sweepstakes and contests, and it tends to be more periodic. We didn't talk as much about charitable sweepstakes, and I'm happy to talk about it with anybody who wants to. Those are sort of a hybrid and largely unaddressed, except for in 2 states, beast. But you know, those tend to require more registration as well, because of the charitable fundraising laws. But you know, again, it's sort of, well, how can we come up with the most compliant strategy possible? And to add to your looks like a duck, quacks like a duck, you know, to the extent you're adopting a gambling shell to your promotional sweepstakes, that's going to raise the risk considerably just because of that. So it's always important to think about, well, you know, what am I doing that raises the risk, and how can I maybe lower that risk with small changes?
Let me say one thing.
Thinking about compliance.
One thing I will say about risk, and another point, I don't know that maybe when my computer died that you made about the sweepstakes that are sort of continuously running and there's no gap, and it's really just a never-ending sweepstakes with different sort of tranches. But what I have found in every enforcement action I've done, both civil, regulatory, and criminal, the issue that you can put in front of a prosecutor or an enforcement agency that always seems to be able to carry the day is the good faith of what you were doing. Now, it may not help you necessarily on a recovery if it's a civil recovery, but I can certainly tell you from a criminal prosecution standpoint, when you have sought legal counsel, you have advice of counsel defense, and you have really sort of worked this out in a white paper kind of memorandum about these are the rules in this jurisdiction, this is how you're doing it. I have yet to see any prosecutor that's willing to take somebody on and go head to head with one of those and prosecute. They will find a way to kick this over in a regulatory civil way, and make it, which is, that's the biggest win of all, to not be dealing with that. So this is really one of those cases where just that ounce of prevention is worth so much more than on the back end.
All right, and I have shown really great technical abilities today, as well as the ability to stay on time. So I'm going to say goodbye. We've run over, and thank you to everyone for joining us today. To the extent that people have submitted questions, we will try to answer them. And if we don't, please feel free to email me and remind me, and I will answer them for you as well. Thank you so much for joining us. Mark, what's the CLE code again for a reminder? Yep,
Giveaway.
ask the hard question.
Yep. Giveaways, plural, 2024.
Thanks very much, everyone. Have a good day.